presentation is addressing the debate of the Eighth Amendment. The Eighth Amendment states, "The state acknowledges the right to life of the unborn and with due regard to the equal right to the life of the mother, guarantees in its law to respect and as far as practical by its laws to defend and vindicate that right." The amendment equates the life of a pregnant woman with that of the embryo or fetus and has created an unworkable distinction between a pregnant woman's life and her health. In this video, we will be discussing the law prior to the Eighth Amendment being voted into the Constitution and as a result of the influence of American policy and the development of Irish law. We will also discuss two famous cases associated with the Eighth Amendment, the X case and PP versus the HSE. We will discuss in depth the definition of the unborn and the effects of the Eighth Amendment on women in Ireland.
The background of the Eighth Amendment has a long and arduous history within the context of the current legal debate. The Eighth Amendment stems back to the pre-1983 fears of judicial rulings allowing abortion through case law.
Governing legislation at the time was the Offence Against Persons Act 1861, which, although good law, was perceived as vulnerable in the eyes of anti-abortion advocates. The rise of these highly influential advocacy groups may be attributed to the landmark Roe v. Wade ruling by the US Supreme Court. Roe v. Wade was centred on the issue of the constitutionality of laws that criminalised abortions. The trial ended with a 72 vote, which ruled that the Due Process Clause of the 14th Amendment of the US Constitution, which extended to a woman's right to have an abortion. It was said that the state's interest became stronger over the course of the pregnancy. It was said that a woman has the right to an abortion until fetal viability. This was later reaffirmed in the US case Planned Parenthood v. Casey in 1992.
McGee v. the Attorney General of 1974 was a key defining case in the lead-up to the Eighth Amendment of the Irish Constitution. This redefined Article 41 of the Constitution on family planning matters. The facts of the case were that of a 27-year-old mother of four who had severe complications while pregnant. She had suffered a stroke due to complications attributed to cerebral thrombosis. Her doctor prescribed the use of diaphragm and spermicidal jelly, as he believed another pregnancy would endanger her life. The Supreme Court ruled with a majority of 4 that married couples have the constitutional right to make private family planning decisions.
In the case of McGee v. Attorney General in 1973, a woman was allowed contraception through prescription as it was a risk to her life if she got pregnant. Although she was allowed contraceptives, the ruling didn't extend to ever allowing the right to an abortion, and it distinguished between the two. During the 1980s, the Society of the Protection of the Unborn Children challenged the distribution of information regarding abortions in Britain. In the case Attorney General v. Open Door Counselling Limited and Dublin Well Women Centre Limited in 1988, they granted an injunction restraining 2 agencies from assisting women to travel for an abortion or helping them with communicating with these clinics. In the Society of the Protection of Unborn Children v. Grogan, they challenged student unions from distributing this information as well about abortion. After the controversy with the X case, a referendum was passed in November 1992 with the 14th Amendment, which specified that the prohibition of abortion would not limit the right to distribute information regarding these services in foreign countries. And the current law today is the Protection of Life During Pregnancy Act 2013, and Section 22 states that it is an offence to intentionally destroy an unborn human life, and if you are guilty of this, you are liable for fine or imprisonment for a term not exceeding 14 years, and the prosecution of this offence needs to have the consent of the Director of Public Prosecutions.
This then went against people's constitutional rights to freedom of travel and freedom to information outside of the country's borders, and the 13th and 14th Amendments were then in place to prevent the 8th Amendment from holding these restrictions, that this was a result of the infamous X case. The introduction of the 8th Amendment into the Constitution acted as a barrier to women in ways other than access to an abortion. As an act to prevent termination of pregnancy, injunctions were put in place to prevent from receiving information on abortions and from contact to the UK.
The Attorney General v. X 1992 is a key case in Irish law, as well as being a very famous case regarding the 8th Amendment. The facts of the case are that a 14-year-old girl became pregnant after being raped by an older man. Traumatised by her pregnancy, her and psychiatrist gave evidence that she would take her own life if she had to continue her pregnancy. She travelled to the UK to England for an abortion with her parents, and her parents asked the Gardaí if they should provide DNA evidence from the abortion to prove her daughter was raped. Instead of helping with that, the Gardaí notified the Attorney General's office. The Attorney General got High Court injunctions to prevent interference in the life of the unborn and to prevent the girl from leaving Ireland for 9 months. She came home. Judge Costello said that there was a real danger to the life of the unborn if these injunctions were not granted. Suicide was not seen as a real and substantial risk to the life of the mother. After national uproar, the Supreme Court, by majority, reversed the High Court injunctions. They effectively concluded that suicide is a real and substantial risk to the woman's life and that determination must be necessary in order to save her life. If other steps would be effective, an abortion would not be permitted. After this case, the X-case test was established. It states that a risk must be real and substantial to the woman's life, not to the health, and there is no entitlement for an abortion in cases of rape or incest.
Right. The PP versus HSC case in 2014 was a pivotal moment in the development of constitutional abortion rights in Ireland. A 26-year-old woman became pregnant, however, later developed brain cyst, which subsequently led to her becoming brain dead. However, the hospital decided that they would keep her body alive on the off chance that they might be able to save the child. The woman's condition began to worsen, however, the hospital still kept her body alive to save the child, even though the child had very little chance of survival. Even though the woman had the right to dignity, the woman's condition began to worsen, however, the hospital still decided to keep the woman alive to save the child. She had the right to dignity and privacy, however, it was ruled that the right to the unborn child would prevail in such cases. So, after a long legal battle, the High Court ruled that the right to life was not absolute and to continue somatic support would deprive the woman of her right to dignity and death and put her family under unnecessary distress. The court then ruled that the somatic support could be withdrawn.
Under the Eighth Amendment, the meaning of an unborn was unclear, and from what point was the unborn protected by the Eighth Amendment, whether it be from conception or implantation. The case of Roach v. Roach considered whether 3 frozen embryos had a right to life. It was determined by the court that embryos created outside of the womb are not protected by the Eighth Amendment until they are implanted. This also suggests that ectopic pregnancies can be lawfully terminated as the embryos are outside of the womb. Therefore, according to Lord Denham, an unborn is established after an embryo is implanted, because the concept of an unborn envisages a state of being born, the potential to be born, the capacity to be born, which occurs only after the embryo has been implanted.
Life of the fetus is not viable. There is at least an argument that the fetus is not unborn, and it may be lawful to terminate on the basis that the balance of rights shifted in favour of the mother. But as of yet, there is no clear entitlement to an abortion in cases of fatal fetal abnormality. The point is not clear and was not addressed in the 2013 Act. In relation to if the entity in the womb has fatal abnormalities, which means that he or she is not capable of being born alive, a plausible argument has been made that states a fetus may be unborn for the purpose of the Constitution, but this has not yet been accepted as law. In the case of DB Ireland 2006, the complainant claimed that failure to provide termination in cases of fatal fetal abnormality infringed their European Convention of Human Rights.
For women living in Ireland, abortion can be accessed, but only outside the state, and this will continue to be the primary means of accessing abortion for women in Ireland. This represents an equivocal, murky approach to the issue that relies on our neighbours to sort out complex matters. The 2013 Act offers some clarity, but the process may still result in women being denied abortion, even where their lives may be at real risk. There is a disconnect here as the 2013 Act was considered by the Oireachtas, and that some body was cutting back on supports to women with children. These cuts include phasing out one-parent family payments at age 7, taxing maternity benefits, and reducing children's allowances. As a nation, if we are serious about protecting unborn life, we have to make the option of childbirth as favourable as possible for women and families. There may be a further change in the coming months as a referendum on repealing the 8th Amendment is due to be held on the 25th of May.